Good morning to all participants. My name is Genevieve Boutin. I'm very honored to welcome you today to this discussion, this very important discussion. I'm welcoming you on behalf of the Committee on the Rights of the Child, as well as UNICEF and Child Rights Connect. Let me begin by thanking the co-sponsors of this event, the permanent missions of Germany, Slovenia, and Belgium, as well as the Child Rights International Network. With this event today, we really are keen to shed light on an issue that is either too often neglected or considered not a central child rights issue. But as you will hear today, it is absolutely relevant and essential to the full exercise of child rights. We're pleased to see the interest triggered by this event, which is, we hope, a sign of interest in promoting this issue and finding solutions. And we are looking forward to hearing from our esteemed panelists today. Before we begin, I just want to highlight that the right to remedy is what really truly makes the right a right. Otherwise, it's simply a privilege or a favor. And in fact, when I think of the CRC, I think that the essence of the CRC is that it makes a child a rights holder, not someone whose human rights are being protected by adults as a favor, but someone who equally holds rights, just like adults. So being able to exercise the right to remedy is what makes a child a rights holder, and it's therefore at the core of a human rights approach. And this, which is broadly recognized for adults, is often less recognized for children. Even though it's an integral part of the SDGs and of equitable access to services and justice and combating inequalities, only a fraction of the millions of children whose rights are violated every day come forward and seek redress. Even fewer obtain an effective remedy, effectively hence being denied their status as full-fledged rights holders. Today we will hear about some of the reasons why and the extraordinary obstacles faced by children when they seek justice. We will also hear that these obstacles are not unsurmountable, and we'll see today that a lot is being done across the world by children themselves, by advocates, by civil society, by organizations in order to uphold this very important right. And our distinguished panelists will give us a lot of food for thought in terms of taking this forward for every child. So I look forward to the discussion, the presentations by our panelists, as well as the many interested participants who've already expressed their interest in taking the floor after the formal panel. Let me just say a few logistical comments before I turn it over to our first esteemed panelists. The event is available in English, Spanish, and French. You can see in the chat the instructions for the translations, and there's a wonderful team behind the scenes who's here to assist you if you face any challenges. Participants will have the opportunity to share comments and ask questions at the end by either raising your hand or taking the floor. You can also, of course, chat very actively throughout the event. And I ask, in the interest of having as many of you being able to take the floor as possible, that our panelists limit their interventions to 7 minutes and that interventions from the floor be 2 minutes maximum. And again, you can use the chat for sharing additional insights and comments. And this event is being recorded, so by being here, we assume that you're all okay with that. In the interest of time, I will introduce the panelists as their turn comes to speak, and I will start by a very, very esteemed panelist. We're very honored to be here with you today, Ms. Mikiko Otani, Chairperson of the Committee on the Rights of the Child. Ms. Otani is a practicing lawyer in Japan, and with her remarks, she will set the scene for this discussion by explaining how the committee defines access to justice for children and why the committee thinks that this is key to the full implementation of the Convention on the Rights of the Child. Ms. Otani, you have the floor.
Thank you, Genevieve. Good morning, good afternoon, or good evening. I'd like to start saying that all human beings are entitled to access to justice and the right to remedy. The right to remedy is recognized in the Universal Declaration of Human Rights. As emphasized by the Committee on the Rights of the Child, I quote, "For rights to have meaning effective remedies must be available to redress violations. End of quote. Access to justice as the ability to seek and obtain remedy when rights are violated is inherent to status as a rights holder. Access to justice for all is also key to promote just, peaceful, and inclusive society as included in the SDG target 16.3. So children as rights holders are entitled to access to justice and the right to remedy. There is no true child rights approach, as Genevieve also highlighted, without access to justice to all issues of child rights violations, and therefore an essential issue for the committee. Access to justice makes a child right a true enforceable right by enabling children to claim rights and obtain remedies. It is for the child with disability who is excluded from school. It is for the girl who is victim of sexual violence. It is for the child from a poor family who is denied social benefits. It is for children whose present and future are jeopardized by climate change. And it is for many more children whose rights are violated. Children, because of their dependent status, not only face the same obstacles to justice as adults, but also other specific obstacles in addition, such as their dependence on adults to obtain information on their rights and where to seek help, navigate and understand the justice systems, pay for related expenses. In most countries, we know that age restrictions make it impossible for children under a certain age to initiate and participate in proceedings. Judicial and administrative procedures are generally not adapted to children. Specialization of professionals is lacking. Legal aid is insufficient. Support services are rare. So this is the reality. Also, social norms still often make it unacceptable for children to seek redress when their rights are violated. As a result, while millions of children have their rights violated every day, only a fraction come forward and seek redress, and even fewer children obtain an effective remedy. This is the denial of children's status as full-fledged rights holders, and we cannot accept it to continue. The entry into force in 2014 of the optional protocol to the Convention on the Rights of the Child on the Communication Procedures, known as Opec, and the subsequent development of relevant jurisprudence by the CRC committees have been a milestone for the recognition of children's rights to effective remedy and to enhance access to justice at the international level. But this mechanism is to fill the gap in children's right to effective remedy at the national level. Access to justice for children should be realized at the national level through judicial and non-judicial avenues, while more ratification of the Opec by states and more use of the Opec by children should be promoted. More efforts should be made to strengthen access to justice for all children in the world, including children in the most vulnerable situations at the national and local level. Despite the recognition of the right to remedy and access to justice for all people, it still seems in the minds of many inconceivable or unacceptable when it comes to children. There is to date no coherent, concerted, or systematic work done for access to justice for children, neither by states nor by other international actors, while extensive resources are invested in access to justice generally. Due to the fact that children have particular rights and needs, and that they can be realized only with tailored measures adapted to their age, maturity, and evolving capacities, general measures designed for adults is not enough. Also, when it comes to children and justice, focus is generally exclusively placed on children in conflict with the law and child-friendly procedures in court. leaving aside the core issue of access to justice for millions of children whose rights are violated every day. The lack of conceptual clarity may contribute to the lack of a clear agenda, advocacy, and action on the ground, and may also impede proper monitoring of states' accountability in this respect. There is a need to advance a more holistic understanding of access to justice for children, encompassing all its forms, criminal, civil, and administrative justice, as well as economic, social, and cultural justice. For all these reasons, it is very important to highlight the efforts by community members, lawyers, ombudspersons, courts, governments, and many more who do work every day to ensure children's access to justice. To scale up similar efforts and identify what more should be done. We hope to start placing the issue of access to justice for children on the international human rights, development, and rule of law agendas, and showcase good examples and their very concrete, life-changing impact on children. Thank you very much. Back to you.
Thank you so much, Madam Chairperson, for highlighting so many important points and framing the issue. I particularly appreciated you highlighting the impact of social norms also as a limiting factor in equitable access to justice. And of course, the central role of the Opec as an instrument to promote equitable access to justice, which I know we will come back to in throughout this discussion. Let me now turn over the floor to two very impressive panelists, Ms. Dohyeon Kim and Ms. Yujin Kim, a child and young climate activists from South Korea. Dohyeon and Yujin are climate activists from Youth for Climate Action in Korea. They are both plaintiffs in a lawsuit filed in 2020 on the grounds that the South Korean government's inadequate climate plans are violating their constitutional rights. We look forward to hearing from them why they have decided to seize the court and to share their experience as plaintiffs, as well as suggestions on how we can all work together to better ensure equitable access to justice for all children. Over to you.
Thank you so much. So my name is Yujin, and I'm an organizer with Youth for Climate Action Korea, which is a youth-led organization based in South Korea, working to create meaningful policy change that can limit global warming below a 1.5 degrees Celsius level that was agreed in the Paris Agreement in 2015. Our demands are that every step in this transition toward saving our future be just and equitable. And we originally started off in 2019 as a handful of young people looking for ways to take action on the climate. And we've held several school strikes for climate, which you can see in the top left photo here. We've also had other numerous strikes, big and small, had sit-ins, and of course in the photo in the right is us moving everything online since the pandemic hit. Aside from the strikes, we've also been meeting policymakers. As you can see in the left, we were meeting with the Minister for Environment in South Korea, and the bottom photo is the Superintendent of Education in Seoul. And we've also been facilitating and participating in civil discourse around climate, and also have had lobbying campaigns. We're now an organization with about 100 members across the country, and we've been operating online in the past year and a half. So in March of 2020, we filed a constitutional lawsuit on the grounds that the government's inadequate climate action is directly infringing upon several of our rights that are outlined in the Constitution. So as I just mentioned, in 2019, we'd been holding numerous strikes, doing sit-ins, meetings, and lobbies, yet change was painstakingly slow, especially in the political sphere. And we had a lot of important deadlines coming up, such as the submission of South Korea's nationally determined contributions to the UNFCCC, the long-term emission reduction scheme, and also the parliamentary and presidential elections. And with such momentous events coming up, we realized that time was really running out for the government to be making these decisions, and we needed a stronger measure that which eventually we realized would be a lawsuit. And if successful, it would force the government to strengthen its climate goals in line with the Paris Agreement, which at the moment is not. Also, most of the organizers in Youth for Climate Action Korea are below age, and youth civic engagement in South Korea is socially largely frowned upon. And we've had a lot of people tell us, oh, you should be studying in the classrooms, not lobbying or doing something else that would interfere with your studies. And also, the avenues through which young people can take civic action are extremely limited. Young people aren't allowed to participate in any political activities, which not only includes voting or joining or campaigning for a party, but also publicly expressing political support for certain political parties. And we had extremely limited windows to act. And that was another reason why we had to choose a lawsuit. So we partnered with an NGO specializing in taking legal action for the climate and environment. And in our final lawsuit, the rights that we discussed in the claim were those outlined in our constitution, which include the right to a clean and healthy environment, our right to life, our right to pursue happiness, and our right to equality, all of which would be infringed upon if the government continues failing to act on the climate crisis, because we would be left with a world that does not contain adequate resources for us to continue a sustainable lifestyle, and one which would be filled with increasing climate catastrophes and events that really a scientist don't even know the full extent of. And
Yes, next slide, please. So after we filed this constitutional appeal, it took just about 10 days for it to pass the preliminary review, which basically means the court has decided to hear our case. And this was essentially the first hurdle we had to clear. And we were very much glad about this because we had not felt fully confident about it before. In fact, several legal experts have told us that we may lack the standing to sue from the beginning, meaning we would not be able to meet all the standards required for a party to bring an actual lawsuit. But despite such concerns, fortunately, our claim is now officially under review by the court. However, this is not to say that our win is guaranteed. We quickly realized that this would be a very long, very hard fight when the government, the defendant of the case, filed a written response to our claim. In their written response, the government argued that plaintiffs don't sustain any direct injury related to climate change. They also said that the right to life, the concept of right to life is irrelevant here in this case because that kind of right is mostly brought up in more extreme cases like physical abuse. They also said that they have done enough to tackle climate change through establishing greenhouse gas reduction goals and so on. But in reality, we knew that none of these policies have worked properly enough to protect our future because we were still experiencing climate disasters like extreme hot waves and more frequent typhoons were hitting our country, and that was our direct experience. So right now we're just clinging on to this lawsuit, and we cannot wait to see what happens next and in what direction this lawsuit is going to move forward. Now, looking back on filing this lawsuit was undoubtedly a meaningful and empowering experience for me and all of the plaintiffs. By working with the lawyers who represented us, I learned that the government's inaction on the climate crisis is not just immoral, but also wrong from a legal perspective and a human rights perspective. So I started to use law as a tool to, articulate my argument and fight for my future. And that really felt empowering. That was an awakening experience, especially because before filing this lawsuit, I used to feel like law was this a very vague and distant set of sentences rather than something that is closely connected to me and my peers. So that was a very positive experience. But what we need to remember is that very few children, very few children get free legal advice and assistance to file a lawsuit of this kind. We were lucky, but if the lawyers hadn't offered help for us, this lawsuit also would have not been able to happen, mostly because we as children tend to lack information about access to justice. For example, not long ago, I didn't even know that minors were eligible for a constitutional lawsuit. So I had never considered this as an option that I could somehow choose to further my cause and protect my rights. In Korea, actually, there are many systems like this constitutional appeal that citizens can use to challenge human rights violations. There are civil claims, there is petition with the National Human Rights Commission, and there's also the constitutional complaint that we used. But I think most of these systems actually fail to adequately help children because they are not built in a child-friendly way. Sometimes they use too complicated and vague terminology that is very difficult for a child to understand. And other times, children may feel simply unsafe to seek justice. I'd like to introduce an example from my country. Next slide, please. So in 2018, South Korea saw a massive flood of confessions by students who spoke out on sexual violence that happened on school grounds. And as you can see, this is a photo of a school, and the students used Post-its to make the sentences like "me too" and "with you" to report on sexual violence that happened in their school. So these so-called school Me Too revelations caused massive public outrage in my country and allowed people to finally see, to clearly see the rape culture that has persisted in schools for years. But unfortunately, these brave students did not get the justice they deserve. About half of the alleged teachers overall have come back to school instead of being dismissed from their job, which is what was supposed to happen, obviously. And students who reported on violence to this day, they often face victim blaming both by their teachers and their peers at school. And I think this is probably why so many of the people who came forward were graduates, not students currently enrolled in schools. This shows how much power a teacher can exert over a student in schools. And I think the students are feeling very much unsafe to report on these kinds of violence and discrimination, even when the government and local education offices have created reporting systems and created platforms for them to share their stories. So I think what we can really take from this example is that if we really want to give children access to justice, setting up a reporting system is simply not enough. We must ensure that children are in safe environment where they feel like it is fine to report on these experiences without any external pressure that is unjust. Next slide, please. Not just as a climate activist, but as a young person, overall, I think people care very much about protecting children and giving us special care. But what I realized over the past years is that they care less about giving us agency and the actual tools to challenge the violation of our rights. And I really do think that it is time for us to change the perspective on children, change the discourse that surrounding children. and start seeing us as defenders of our own rights rather than powerless victims who need special care and protection only. And I think that is essentially what children's access to justice is about, giving them tools and agency to protect themselves. And that is what today's event is also about. So thank you so much for giving me an opportunity to give this presentation. Thank you.
Thank you so much, Yujin and Dohyeon, for sharing this really outstanding experience and for highlighting for us, allowing us to learn both from your decision-making process and taking this claim forward, as well as the challenges that you note that stand in the way of equitable access to justice, and not least safety and protection, agency and tools. So really, thank you very much for these words of wisdom. I'm sure you will have a lot of questions in the ensuing discussion. It is now my pleasure to turn over the floor to our next panelist, Ms. Amparo Peñaherrera. She is part of the Federation of Women of Sucumbíos, which is located in the Amazon region in Ecuador. She is in charge of coordinating their gender-based violence work. As we will hear in her presentation, Sucumbíos is a province located at the border with a conflict-affected zone in Colombia and a corridor for migrants from Venezuela. Amparo will describe the work of the Federation of Women in providing unique social and legal support for girl victims of gender-based and sexual violence to seek justice and obtain reparation. We very much look forward to hearing from you. Amparo, the floor is yours.
Buenos días. Primeramente, un saludo especial en nombre de la Federación de Mujeres de Sucumbíos, organización popular a la que pertenezco. Y decir que estoy profundamente conmovida por el testimonio de las jóvenes defensoras de los derechos de Corea. Y bueno, pues desde aquí un abrazo a ustedes y realmente me edifica conocer esa experiencia. Quiero comenzar diciendo que la provincia de Sucumbíos está ubicada en la Amazonía ecuatoriana. Es zona de explotación petrolera y comparte frontera con el vecino país de Colombia. Y gracias a esta ubicación geográfica, la provincia tiene unas características sociales y económicas particulares. Por un lado, es muy rica en recursos naturales, fundamentalmente el petróleo, pero por otro es muy pobre, porque los recursos económicos generados de esta explotación no regresan a la provincia y no se invierten en su desarrollo. Esta realidad pues afecta fundamentalmente al acceso a derechos de las niñas, niños y adolescentes. La provincia se encuentra también afectada por problemas como una débil presencia del Estado, un elevado índice de desempleo, limitada cobertura y acceso a los servicios públicos, contaminación medioambiental, inseguridad ciudadana y violencia derivada de la presencia de actores armados, regulares e irregulares. Un alto índice de violencia basada en género y una grave debilidad del sistema de protección a niñas, niños, adolescentes y mujeres, que no garantizan el acceso y la protección de los derechos. Al estar tan cerca de la frontera colombiana, pues Sucumbíos es destino de un alto porcentaje de personas de movilidad humana provenientes tanto de Colombia como también de Venezuela. Y es en este contexto donde desarrollamos la actividad la Federación de Mujeres de Sucumbíos, que mantiene 2 servicios de atención y protección para mujeres, niñas, niños y adolescentes sobrevivientes de la violencia basada en género. Desde el año 2004, una casa de acogida que se llama Casa Amiga y el Centro de Atención Externa La Puerta Violeta desde el año 2019. La Federación sostiene una relación de cooperación con UNICEF que nos ha permitido realizar este trabajo. Y bueno, gracias al apoyo de UNICEF, el Centro de Atención Externa La Puerta Violeta cuenta con un equipo conformado por una psicóloga, una trabajadora social y una abogada que ofrece el servicio de atención integral e interdisciplinaria a niñas, niños, adolescentes, víctimas y sobrevivientes de violencia sexual, fundamentalmente incesto. Y este equipo es el encargado de acompañar y de sostener a las sobrevivientes y a sus familiares a lo largo de todo el proceso legal, terapéutico y de trabajo social, hasta conseguir la restitución de sus derechos. Las víctimas llegan a nuestro espacio a través de referencias realizadas, ya sea por las juntas cantonales de protección de los derechos de la niñez y adolescencia de todos los cantones de la provincia, de los cantones más alejados, donde solamente se puede acceder a través del río y son varias horas de movilización en canoa. Son referidas también por instancias de administración de la justicia como la Fiscalía, las unidades judiciales, por escuelas, por colegios, por organizaciones de mujeres y también por agencias y organizaciones de ayuda humanitaria presentes en la zona. También hay un gran porcentaje de niñas, de niños y de adolescentes que son referidos por sus propios familiares y en muchos de los casos han sido llevados por sus madres, que a su vez han sido también víctimas de algún tipo de violencia dentro del ámbito intrafamiliar. El incesto es un delito común e invisibilizado en nuestra provincia y sin embargo este delito no está tipificado como un delito autónomo en el COIP, que es el Código Integral Penal, por lo que no es de extrañar que no existan estadísticas oficiales. Según información vertida por el fiscal de delitos sexuales de la Fiscalía Provincial de Sucumbíos, más del 95% de los delitos sexuales cometidos contra niñas y adolescentes se cometen en el ámbito familiar y cuyos perpetradores tienen vínculos sanguíneos con las víctimas y pueden ser sus padres biológicos, abuelos, tíos, primos o también sus padrastros o cuñados. Esta realidad pone de manifiesto que la familia no es el lugar más seguro para estas niñas, para estos niños y adolescentes. Y basadas en la experiencia de estos años de trabajo en los dos espacios de atención, conocemos que lastimosamente el incesto es un lugar común para muchas mujeres que ahora son adultas. Un alto porcentaje de niñas, de niños, de adolescentes sobrevivientes de la violencia sexual que son apoyados desde nuestro centro son hijas, son nietas de mujeres que a su vez han sido sobrevivientes de violencia intrafamiliar y incesto. Este tipo de delitos están presentes de generación en generación y hacen que coexistan varias víctimas directas de violencia sexual en cada familia afectada, por ejemplo. Y como consecuencia de esta violencia sexual ejercida contra las niñas y adolescentes, hay un porcentaje también alto de embarazos en adolescentes y en niñas, que en algunos casos las víctimas, tras haber sido violadas por un familiar y en estado de embarazo, son expulsadas de sus familias y repudiadas por sus comunidades. Hay algunos casos que han sido detectados por servicios de atención sanitaria que no han denunciado a tiempo como corresponde y está establecido en la ley. Al contrario, las niñas y adolescentes han sido obligadas a la maternidad y han sido atendidas como si se tratase de mujeres adultas embarazadas, aún en casos en que las víctimas tienen algún tipo de discapacidad. Desde el Centro La Puerta Violeta, el equipo de profesionales acompaña a las sobrevivientes en los procesos legales, litiga en el Tribunal Penal en primera instancia, en la Corte Provincial en caso de exigir apelación, que es la segunda instancia, y en algunos casos va hasta la Corte Nacional en procesos de casación de la sentencia. La psicóloga terapeuta provee de atención especializada, brindándole espacios de contención y apoyo emocional para que puedan desarrollar herramientas para su recuperación emocional y reconstrucción de su poder personal. Mientras que desde trabajo social se trabaja en la búsqueda de recursos para la restitución de sus derechos en todos los ámbitos, acompañando a las familias en sus propios procesos de recuperación y consecución de sus planes de vida. En el último año, la incidencia de la atención está en 136 niños, niñas, adolescentes atendidos. El acceso a la justicia es uno de los objetivos de nuestro trabajo y en ese sentido, a lo largo de estos años, hemos visto que sí hay avances, pero también hay nudos persistentes. Y actualmente existen varias barreras en el acceso a la justicia que enfrentan las niñas, los niños, adolescentes y se sitúan en diferentes niveles. En lo familiar y comunitario, pues existe una falta de apoyo tanto de las familias como de la comunidad, miedo a las represalias que hace imposible que se pueda revelar estos secretos familiares, estigma social, vergüenza y culpabilización a las víctimas, falta de recursos comunitarios que puedan brindar apoyo dentro de las comunidades y la naturalización de los delitos sexuales cometidos en el ámbito familiar. Las familias y las comunidades no están educadas para la denuncia y no tienen información necesaria. No existen mecanismos de remisión de las víctimas sobrevivientes a los servicios sectoriales. Y en el nivel sectorial, por ejemplo, en el ámbito de la salud, en muchos casos el espacio físico no asegura la privacidad y los casos no se manejan con la adecuada confidencialidad. No existe personal suficiente capacitado para la atención. Hay un nivel bajo de capacitación en violencia sexual y una ausencia de profesionales de psicología. Al parecer, es como si la atención en los subcentros de salud solo se centra en la atención médica. Y con relación a la infraestructura, no hay salas especializadas para atender a las víctimas de violencia sexual en los cantones. Y lo que es peor es que no se les informa adecuadamente a las adolescentes sobre el derecho al uso del anticonceptivo oral de emergencia, tampoco se lo administra como dicen los protocolos. Y no se aplica en los casos que contempla la ley la referencia para la interrupción del embarazo, tanto en casos que ponga en peligro la vida de la madre como en personas con discapacidad. En el sector de la justicia podemos señalar impedimentos que tienen que ver con el uso de los servicios y la protección de los mismos, que están relacionados con la disponibilidad y el horario de la atención, la dotación de recursos humanos insuficientes, las características del proceso, la inadecuada infraestructura, las necesidades de capacitación del personal y la falta de intervenciones que aseguren la integralidad de la atención. Hay mucha invisibilización de las necesidades de la víctima más allá de la atención médica clínica tradicional. Y con relación a la policía, casi siempre existe una falta de apoyo, una carencia de personal formado para la atención en estos casos. Y también se da la situación que hay mucha sobrecarga de trabajo, con lo cual hace difícil que cumplan con compromisos adquiridos, como por ejemplo, diligencias como reconocimiento del lugar de los hechos o entrega de citaciones para procedimientos. No manejan material informativo de divulgación, no tienen suficientes recursos, no tienen carros, no tienen gasolina, en fin. Con relación a la infraestructura, no hay privacidad para hablar cómodamente y tampoco tienen insumos. Y en este caso, por ejemplo, de las niñas, de los niños, de las adolescentes sobrevivientes de violencia sexual, se ve claramente que no existe ninguna especialidad para la atención. Son tratados como si fueran personas adultas. Con relación a la reparación de las víctimas de delitos sexuales de las niñas, niños y adolescentes, es una asignatura pendiente en la justicia ecuatoriana, pues las medidas que se toman por lo general se centran en pagos de indemnizaciones económicas que son difíciles de conseguir, porque son sumamente altas y porque los perpetradores están privados de la libertad y porque las familias son de escasos recursos económicos. Jamás se va a conseguir que una indemnización económica que consta en la sentencia pueda hacerse real. Nosotras trabajamos en la necesidad de dotar medidas reparatorias reales que apunten más a la implementación de políticas públicas, que apoyen e intervengan en la comunidad y en la transformación de la vida de las sobrevivientes, pasando por la restitución de todos sus derechos. De hecho, el Centro de Atención Externa, la Puerta Violeta, se está formando para dar los pasos siguientes en consolidar una propuesta efectiva de restitución de derechos a niños, niñas y adolescentes basado en las propias necesidades de los niños y escuchando a las víctimas cómo quieren ser restituidas sus derechos. Hay algunos logros que no quiero dejar de mencionar y que han sido difíciles de conseguir, como es el caso de la consecución de la interrupción del embarazo. Por primera vez en nuestra provincia de Sucumbíos, en una niña de 10 años y en una adolescente de 16, acogiéndose a las causales que establece la ley ecuatoriana dentro del COIP. Para nosotras es importantísima la atención que se brinde a las niñas, a los niños, a las adolescentes, víctimas y sobrevivientes de la violencia sexual. Es profundamente conmovedor la capacidad de resiliencia que tienen estas sobrevivientes, estas víctimas, y eso es en realidad lo que nos hace continuar con el trabajo en situaciones tan duras y tan difíciles, y es algo de lo que nosotras consideramos que no vamos a poder dejar ni aunque quisiéramos, porque es un compromiso inclaudicable. Muchas gracias.
Muchas gracias, señora Peñaherrera, por sus palabras, pero además por su trabajo muy importante. Thank you very much for highlighting the importance of access to justice for meaningful rehabilitation and recovery as well, and the nature of reparation measures that can be both realistic yet comprehensive and sufficient to break an intergenerational cycle of violence. Thank you. This was very inspiring. I'm now delighted to turn over the floor to Ms. Aneta Genova. Ms. Genova is a lawyer in Bulgaria, a human rights lawyer who is defending in particular persons with disabilities and victims of domestic violence. And she dedicates herself to providing legal support and litigation for children with mental disabilities, often the most vulnerable children in a society. And she helps ensure, for example, that they can stay with their families or to be included in schools. We very much look forward to hearing about your work, Ms. Genova. The floor is yours.
Thank you very much. Thank you to the previous speakers and their constant efforts to make the place a better place for the children, which means for everybody, actually. I'm going to share with you some thoughts which are coming from our work in Bulgaria, my work with children and adults with psychosocial disabilities. Of course, children with disabilities have all rights that all other children have, and they are facing the same barriers, the same obstacles. But unfortunately, they are facing some additional barriers in their access to rights, including access to justice. But the access to justice is the key factor for the access to all other rights, like rights to life, freedom from inhuman and degrading treatment, family rights, family life, and other rights. There are many obstacles, but I will mention only few of them. The first one is, of course, the age and the legal barriers coming with it. The restrictions specified by the law may seem natural because the child immaturity, but the child needs specific support from the adult, a parent or a guardian. But what happens if the child doesn't have an adult who cares about its individual interest, if the child is not living in the family? It happens very often to the children with disabilities, especially those placed in care facilities. The adult who acts as a child guardian usually doesn't have special relationship with the child. He is not well informed about the family where the child was born. The adult is responsible for adult children as well. He is a professional, and the obligation as a guardian are just part of his professional duties. And he must be loyal to the authority that manages the residential services. What is happening when the interests of the care provider, the authority, and the child interests are not the same? Of course, the authority will have priority. The individual interest of the child is gone. Currently, I and my team work on such a case. There was a violence in a group home. The equality body in Bulgaria recognized discrimination, but the victims were not constituted as parties in none of the court procedure. We try to bring attention to many authorities that the law requires the child to be a part of every court procedure dealing with his or her case, and every child who went through violence has the right to be compensated. The answer we received from everywhere was negative. Even we received a letter from a director of the group home who informed us that the case is closed and it is not in the best child interest even to discuss this case anymore. Here is how the children victims of violence were deprived from access to justice because of their best interest. How it can be right and legal. The combination of the age, legal status, and lack of independent adult who has the right to act in protection of the child interest and the lack of possibility for the civil society to bring this case into the court made this possible. The prejudice also may be used for deprivation from access to justice. In the same case, mentioned above, many experts try to convince us that these children forgot everything, they didn't feel anything, or even the violence was nothing very serious. In many cases, the people who are responsible to ensure the access to courts for the children don't think the children may express themselves at all, and especially if the child has difficulties. Such a child is labeled as nonverbal or not able something. These labels can easily lead to exclusion of the child from the possibility his point of view to be taken into account. And it is one of the ways of exclusion of the child from access to justice. The child can be dependent for care, which leads to some additional obstacles. The child may be bound emotionally with the perpetrator of the violence, and this must be recognized and considered properly from the experts. It may be very difficult. Sometimes the lack of preparation to deal with the phenomenon of violence caused blaming of the child for what happened. And here we are coming to the next obstacle. The lack of enough experts prepared to work with children's justice system, the lack of knowledge. Many experts in this field have their own horizon, and in many cases they consider as possible only this they can see from their point of view. In many cases, the experts may ensure the courts that there is nothing in place to help of the child with disability because the child has no ability or nothing else is possible. But the fact is that there are many possibilities for inclusion and access to rights which simply are out of their field of vision. Sometimes it takes a lot of time and efforts to change this attitude. Here is a parallel. In 2007, the Bulgarian state considered the children with intellectual disabilities not educable. The Validity Foundation, former MDAC, challenged this and started a case against Bulgaria and proved this exclusion from the rights to education is discrimination. Later, I will provide in the chat box the link to the case. After we won the case, there was a lot of advocacy work, and in the end, at least legally, all children with disabilities have equal right to education. This is how the horizon may be expanded and inclusion may start to happen. Once we achieve something like that, we never have to stop. The legal victory is just a step away. We have to be close to the real life and real children and to observe the process of the change from higher values point of view. If we stop, the old habits will come back and exclusion will have a new face. And how the change may become sustainable, how the children may have real access to justice. The efforts of experts from many fields are needed. We need people who are able to communicate with children properly and provide him or her with information, no matter how serious difficulties the child may have. We need to be open and curious to the new achievement of science and technology. We all know they may expand the horizons far from our yesterday dreams. We have to examine very carefully our understanding about what is possible, because every new day shows we were not right when we said something is not possible. Same is about the access to justice. Thank you very much for your attention.
Thank you so much, Ms. Genova, for describing how you work in a comprehensive and multi-sectoral manner to provide children with unique abilities a chance to exercise their rights of access to justice. And you've painted for us a really, really good and very informative picture of all of the support services that are required for this to happen. Thank you so much. It is now my honor to turn the floor to our last panelist, last but not least surely, Ms. Theoni Koufonikolakou. She is the Deputy Ombudswoman for Children's Rights in Greece. She's also the chairperson-elect of the European Network of Ombudspersons for Children. She's an attorney at law, specialized in human rights protection and domestic violence cases. And we're delighted that she has joined us to describe the role of independent human rights institutions in supporting children's access to justice, in particular, how such institutions receive and handle complaints for children. We know how key this role is, making justice more accessible and being more adapted to children's needs in courts, and we look forward to hearing more from you. Thank you so much.
Thank you for the kind invitation, and many thanks to the brilliant panelists before and to our young activists from Korea. We learned a lot. I'll try to be as practical as possible, but I was wondering whether I'll be able to share my screen. Is it?
That should be feasible.
Yeah, I can. Yeah, no, yeah, I can share my screen. Yeah, thank you. So, let me start by saying the obvious. You know, children do not participate in decision making, and even though they are vulnerable to all sorts of violations, they are often ignored by adults, or even if they manage to reach justice, are often considered unreliable witnesses. And these are the devious particularities and challenges in children's rights. The fact that the care of children is entrusted to adults that in some cases stand between them and the exercise of the rights, as well as the dominant representation of childhood as merely a phase of transition in which a child has to absorb knowledge but has nothing to share or express yet. The United Nations Convention on the Rights of the Child, besides protecting children, promotes a social representation of the child that differs from what we know and collectively expect so far. The child does not only exist in anticipation of its adulthood, but is a rights holder that participates, expresses its views, and is credible, is reliable despite its vulnerability. There is a long way ahead to achieve the shift of this paradigm, and I think that national human and children's rights institutions have an especially important role to play in that. The best way to examine the possibilities and limitations is to have a look at how access for children is enshrined in General Comment number 2 of the Committee on the Rights of the Child. Now, according to the comment, first, NHRIs must have the power to consider individual complaints and petitions, including those submitted on behalf of and directly by children. And furthermore, NHRIs should be geographically and physically accessible to all children, with an emphasis to all children. And in the spirit of Article 2 of non-discrimination, they should proactively reach out to all groups, in particular the most vulnerable and disadvantaged. Now, having said that, the Greek Ombudsman, within its mandate to protect and promote children's rights, has adopted UNCRC as a guide for all its interventions that include handling complaints, advocacy interventions for the adjustment of the legal framework and administrative practice, inspections, as you can see everywhere in prisons, childcare institutions, hotspots, camps, promotion, raising awareness on children's rights, and reports regarding all issues related to children's rights to inform the public. The Greek Children's Ombudsman can receive complaints by anyone, including children, and has the right to mediate in both public and private entities and individuals, as well as to perform inspections and collect evidence from the field and from services. What is important to underline here is that not all children's rights institutions have the same mandate. Some do not receive complaints, some do not have the right to address their recommendations to individuals or private entities, and certainly not everyone has the same modus operandi. The other important aspect of acknowledging children's presence and needs is that even though the set of competencies I described is demanding and requires a lot of resources, it's also insufficient. This is because often children or professionals close to children do not identify violations and are not aware of how they can seek help, counseling, and/or support. Therefore, every ombudsperson is obliged to exhaust its resourcefulness and resilience to make each authority genuinely accessible to children. So let me virtually walk you through the practical aspects of the accessibility of these mechanisms. First, we have complaints. Children can submit their complaints online, or they can send us an email in a special address we have only for children, or use our hotline. What is interesting is that children prefer using the email address of our children's hotline because they feel that the procedure there is more informal and therefore safer from them. It is our obligation to ease their overwhelming stress and to empower them and convince them to submit a complaint where appropriate or give them other options. When the incident, of course, reported is related to domestic violence or the dangers of abuse and exploitation, an emergency inquiry by the Ombudsman is followed by referral to the prosecutor, and then we follow the case that is referred to the prosecutor's office. In cases of other violations, we mediate either between the child and any kind of public service, school, health services, social services, or private entities, or even their parents and carers. In our effort to ensure support as long as it's needed, we also mobilize and inform other services. Now, it is important to mention that even though the Ombudsman is not able to impose sanctions, the percentage of successful mediation and ad hoc intervention is significantly high. Children also share more easily during inspections. It is usual during our in situ visits in hotspots, camps, prisons, to see that children approach us and confide what worries them or violations that occur. The Ombudsman, after investigating, immediately intervenes with recommendations and monitors progress. In any case, in order for children to be able to trust anyone, let alone an adult, it is required to establish a relationship and for them to feel that they know both the institution and the very person that is representing it. Therefore, our systematic visits in schools every week are very important in terms of informing pupils of their rights, but also making the Ombudsman's presence and activity known to facilitate visibility and accessibility. An 8-person team like ours, even though it's interdisciplinary and very capable, cannot reach every area of Greece. And this is why we try to address the need by setting up 2 networks that consist of public services and NGOs, as you can see. These 2 networks for children on the move and deinstitutionalization have helped a lot to encourage children that are reluctant to access our institution. So several NGO members of our network working in camps and institutions encouraged children to submit their complaints and get the support they needed directly by the Ombudsman. Additionally, and since we have our young activists with us, our youth councils are valuable allies to our struggle to let families and children know that we're there. And our advisors, when they leave the councils, they become the strongest advocates of children's rights themselves, encouraging their peers to seek for help. So we had in the past complaints submitted by children because of our advisors' mediation. And of course, we have received complaints from our advisors. Now, the refugee and migrant crisis over the last years has multiplied challenges in the field, particularly because of the overwhelming and desperate conditions of reception, but also the lack of interpretation. It was impossible for us to receive complaints in Farsi, Dari, Urdu, or Arabic. So we tried, along with UNICEF support, to let children know we're there by introducing a microsite that has info and practical guidance in common violations. Last but never least, we also devoted a lot of time and effort in training teachers and personnel from other educational services into identifying violations, but also acting quickly, swiftly to address the emerging needs. In many cases, teachers after training were able to nourish a meaningful relationship with students that allowed them to recognize the problem and submit a complaint themselves, or encourage the child to do that depending on the case. Now, it is also important, this is the last part, to highlight the advocacy interventions that are based on the experience mentioned. In Greece, the system of child protection, like elsewhere, I assume, is fragmented, understaffed, insufficiently regulated, and uncoordinated. Therefore, it is one of the most significant priorities of the authority, apart from everything I just mentioned, to push for reforms, insist, and closely monitor their implementation. Especially when it comes to children's access to justice, the Ombudsman has intervened for mandatory capacity building and training of professionals, of a regulatory framework about children when it comes to the police, the introduction of an interactive children's rights curriculum from an early age, adjusted to all age categories with practical guidance to ensure pupils know their rights and are informed about their options, child-friendly methods of forensic interview to avoid secondary victimization of children, that's also discouraging when it comes to complaints, the introduction of child rights impact assessment and evaluation that will allow us to fully comprehend the impact of decision-making on children, the allocation of human and budgetary resources, of course, to build a sustainable, coherent child protection system, and the introduction of a robust medium long-term strategy for the rights of the child with indicators, with monitoring mechanisms, etc. Now, emphasis on that should be placed especially on children's participation and empowerment to express their views. This is how we're going to receive complaints. This is how children will see us as trustworthy. That was all, and I hope I was able to give you a first glimpse of our challenges and priorities, and thank you very, very much for bearing with me.
Thank you so much, Ms. Koufonikolakou, and really the children in Greece, including migrant children on the move who are in Greece at the moment, are very lucky to have such an advocate as yourself and this wonderful energy. Thank you for describing the tools and mechanisms that your office is putting in place to support children's access to justice and the structural reforms that you are targeting. And I'm particularly heartened that you mentioned the importance of alliances and networks. And I would like to point actually our panelists' attention to an important comment made in the chat by an activist from the Gambia, who's provoking a conversation on networking amongst organizations who promote children's access to justice. So I invite you to respond and have a lively conversation in the chat as well. Now, ladies and gentlemen, today's panel would not be complete without a further mention, complementing the remarks already made by our chairperson, of the CRC's optional protocol on a communication procedure, Opec. This optional protocol allows children in countries that have ratified the OP to file complaints with the Committee on the Rights of the Child when its national avenues have been exhausted. We will now show a short video prepared by our friends and colleagues at the UN Office for Human Rights to showcase the positive outcomes of a recent decision by the Committee on the Rights of the Child under the OPEC.
Pues antes cuando iba al colegio me notaba un bicho raro, obviamente, porque los niños iban y yo no.
She was born in Spain, but she was not permitted to go to school there because she wasn't a Spanish citizen. However, the right to education at primary school level is undeniably a right for every child, regardless of their citizenship status.
Pero algo quizá de estudiar, porque me gusta muchísimo estudiar y además me gusta sacar buenas notas.
Children and those working with and for children can bring problems to the committee as their final destination when they've been searching for an answer to a child's rights violation.
Cada jueves íbamos a recoger firmas, pidiendo firmas por la colección de los niños y mucha gente estaba de acuerdo con nosotros y nos daba su firma, su nombre y apellido. Y los viernes íbamos a cantar canciones, inventar cuentos, inventar canciones, muchísimas cosas, desde la 1 hasta las 2 menos cuarto, estábamos ahí.
They ended up with their lawyer suggesting that they come to the Committee on the Rights of the Child by filing a communication with us. It obviously is a complaint against a state, and so we have to give the state a chance to be able to respond to what has been asked.
Llevamos 2 años y 2 meses luchando.
The committee requested the Spanish government to do this, and they complied. I think what is really interesting about this case and positive about it is that it only took a few months from when the case was filed with the committee to the child being notified that she would be given access to school. And so this really shows how it can make rights real.
Como me había escolarizado a mí, hay que escolarizar a muchísimos niños más para que estén contentos como yo. A mí siempre me ha gustado ser abogada, en plan, abogada la que lucha por el derecho de los niños como muchas personas. Y antes tenía la puerta todas cerradas y ahora, como me dio en colegio, pues ya las tengo abiertas y podré, en plan, si estudio mucho, podré ser abogada.
Hola, señor del Comité de Derecho de Niño. Quiero dar las gracias a vosotros, los que habéis luchado por mi hija. Ahora está escolarizada, estoy contenta y estoy tranquila que mi niña por lo menos que está tomando la tarea. Ahora se ha abierto la puerta para el futuro, para que mi hija pueda conseguir muchas cosas en su futuro. No va a ser así perdida. Se ha abierto la puerta de verdad y muchísimas gracias por todo.
Thank you very much for this inspiring video, and allow me to also highlight that Ms. Anne Skelton, the member of the CRC who you saw in the video, is here with us today, and we hope we will have time to also hear briefly from her. I will now turn over to the comments from the floor, and I remind you of my invitation to also have an active discussion in the chat. We also have an important anonymous query about states and their obligation to engage with the Opec. So I'm sure that this will be addressed by one of our panelists. The first request from the floor comes from a child climate activist from South Africa. His name is Gabriel, and he would like to share his thoughts.
Hello, everybody. My name is Gabriel. I'm from South Africa. I come from the organization called African Climate Alliance, and we work with youth across Africa in different countries. I'm joined today by my fellow activists, Polly and Yola, who are in the chat somewhere, I'm assuming. Yeah, so my only need to speak today is just to say thank you once. Thank you for everything that's being said today. I really do appreciate seeing this perspective, especially as we in South Africa plan things going forward in regards to litigation and actions moving forward. It's always nice to hear and see the inspiration and the inspiring stories from activists around the world. But also my question, if anyone is able to answer it maybe, or just ponder on it going forward as we move, is that of mental health of children. We often overlook it, and it's something that is said, especially here in South Africa. It's go and take a bath, go and take a walk, go and take a run. Nothing is wrong with you, you're just lazy. But the case is everyone has a mental health, and it can fit between good or bad, anywhere in between. And now if we look at it and we realize that there are young people and like specifically children who don't know how and who to go to. And now you add that on to the fact that young people are now fighting for their futures and for their rights and their access to justice. So maybe just highlighting the need for us to always ensure that the mental health of the young person is put forward first. You know, it was mentioned earlier that young people are requested to be in court for certain things for every session, and I can only imagine that there's the toll that must have on that individual. And not to mention you've got the whole world looking at you, because now it's like the youth of the future. It's like, yeah, but youth are also the now, and youth are suffering with mental health and mental illness right now. And so maybe a question, if anyone has the answer of what is being the focal point of it. But if no one does have the answer, just for us all to move forward with that question, as we access and achieve, figure out how we can achieve justice, maybe just taking in the fact that mental health of young people needs to be prioritized and taken to a serious degree. Thank you.
Thank you very much, Gabriel. And I'm sure many of our panelists will have some interest in engaging with you on this as we move forward. It's really great to hear that your colleagues are also here with you today. And as I go through my list of speakers, please, we would be very excited to hear from more child rights activists. So don't hesitate to ask for the floor. The next speaker on my list is Mr. Benoit van Kiersbilk. He is a member of the Committee on the Rights of the Child. The floor is yours, sir.
So thank you for inviting me to take the floor. And I just would like to say how amazing all the examples that we heard are. And I could not stress in a better way all the difficulties and the problem children may face when it comes to accessing to justice. And so Anne Skelton talked about the Opec, and so did Mikiko Otani, the chair of the Committee on the Rights of the Child. So this complaint mechanism, which allowed children to access to the International Committee on the Rights of the Child to address their needs to justice, is extremely important. But we still need many countries to ratify the Opec. Only 50 countries, about 50 countries around the world have ratified Opec, which is too little. And then don't forget that this mechanism is only a mechanism of last resort. This mechanism should really help to ensure that access to justice is available at national and local level. We have seen how difficult it is for a child to reach a court at national level, even a local court. It's even more difficult to reach the Committee on the Rights of the Child, even though we try our best to be accessible, but we will not solve all the needs of justice of all children. This is impossible. And so we have to ensure through this mechanism that access to justice is accessible, is available for all children at local level, with the support of all those actors, NGOs, civil society, Ombudsman for Children, all the people that we heard have a very important role to facilitate access to justice and support children in their need to have their rights to be implemented. Thank you.
Thank you very much, sir. And the committee also plays such an essential role in many, many ways. I can testify to this, having been myself working hand in hand with governments at country level on these important issues. I would like now to turn the floor to Ms. Spela Kosir from the Permanent Mission of Slovenia in New York. And thank you to Slovenia for being a co-sponsor of this important event.
Thank you, and good morning and good afternoon to everyone present today. At the outset, allow me to thank the panelists for their very interesting and inspiring presentations. Promotion and protection of the rights of the child have always been a priority issue of Slovenia's national and foreign policies. My country is fully committed to advancing children's rights, including their right to participate and their access to justice. Slovenia, together with Germany, co-chairs the Group of Friends on the Rights of the Child in Geneva, and my country had an instrumental role in creation of the optional protocol to the CRC on the communication procedure referred to as Opec. The adoption of Opec represents an important momentum in recognizing children's right to effective remedy and for enhancing their access to justice through an international child-sensitive mechanism. Slovenia signed Opec in 2012 and ratified it in 2018. Additionally, we have put in place a decree on the procedure for preparing the response of the government of the Republic of Slovenia to the Committee on the Rights of the Child as regards the communication procedure. Consequently, Slovenia is also a strong advocate for the promotion of ratification of Opec. I would like to take this opportunity also to inform about the 2021 annual informal exchange between the UN Committee on the Rights of the Child and states that Slovenia and Germany, together with Child Rights Connect and the CRC Secretariat, co-organized in Geneva. the event provided the space for informal discussion and exchange of good practices on the Convention on the Rights of the Child and its protocol on the communication procedure. Allow me also to reiterate some of the key aspects of OPIC which relate to enhancing access to justice for children. OPIC empowers children as the rights holders while enabling them to exercise their right to legal remedy at the international level. It fills gaps by providing children the possibility to appeal to an international mechanism when violations are not addressed effectively at a national level. And it centers around children's rights to be heard and participate, while ensuring the respect for the best interest of the child. The discussions today aim to contribute to a better understanding of the importance of access to justice for all children, also in view of achieving the Sustainable Development Goals and fulfilling our commitment of leaving no one behind. It is remarkable to see how children today rise up as leaders. They inspire action, in particularly action to address climate change crisis and ensure the right to healthy environment. Children are at the forefront of action which leads to building better and healthier future societies. It is our responsibility to support children and ensure that they are treated as an integral part and are partners in the efforts to building back better. Slovenia remains committed to promoting and standing up for children's rights. I thank you.
Thank you so much, Ms. Hosier. I now turn the floor to Ms. Franziska Benico from the Permanent Mission of Germany to Geneva, also a co-sponsor of this event.
Hello, good morning. Well, not good morning for everybody, but hello to everybody anyways. As a co-sponsor of today's event and co-chair of the group of friends on the rights of children in Geneva, Germany is very thankful as well for this opportunity to underline the need for equitable access to justice for all children. Thank you very much to all the panelists for explaining the challenges you are currently facing, your main interests and topics of concern, and also for the tools already developed by many of very committed organizations. Germany is also very committed to advance children's rights and stands ready to further empower all children in accessing the relevant information they need and the support and mechanisms to obtain effective remedies for violations of their right. Indeed, we have the problem that access to justice is often neglected as a human right, but it is both a fundamental right in itself and a tool in order to realize other rights. So we need to have a very broad and comprehensive understanding of the right to access to justice. And we need to not only look at children which are in conflict with the law or on procedures which have to be child-friendly, of course, but we also have to look on children's situation from on a day-to-day basis. So to the rights of children who are concerned every day, every single day. For example, on a national level, we had a very popular case recently where our constitutional court took a landmark decision on the German climate policy and children's future, basically, following a complaint that was submitted by several children who were actually only defending their right for a healthy environment to start with. And a very similar case is currently examined in Geneva within the Committee on the Rights of the Child. It's currently under examination for its admissibility, but whether it's admissible or not, there is the possibility for these children to seek justice because Germany has ratified the Opec. And Germany think that the ratification of Opec was really a very important milestone for enhancing the access to justice for children. In this spirit, as my colleague just said, we have also recently organized another event in Geneva in order to raise the awareness for this tool. And I would once again like to take this opportunity to call upon the other delegations who are present today to examine whether there is a possibility for them to ratify Opec more broadly so that more children can regain access to justice in addition to their national procedures. And with this, I thank you very much again for this event, and back to you.
Thank you. Thank you for this important call to your colleagues, member states. I have still a long list of speakers and the time is running, so I'll ask that you keep your remarks short. Now turn the floor to Juan Jose Riva of the Permanent Mission of Uruguay in New York.
Hello, yes, I hope you can hear me. And first of all, thank you to all the organizers for this important event. Uruguay is really pleased to be here. We give particular importance to this HLPF as per the commitment of Uruguay to the 2030 agenda and the overall achievement of the SDGs. But moreover, the link between the SDGs and the rights of the children lies very close to our interests as a nation, reflected both in policy and legislation. These 17 SDGs that will be referred in this HLPF we consider them interlinked to the rights enshrined in the Convention of the Rights of Children. And this event tackled a very important aspect as it is the equitable access to justice. As Uruguay is, as you may know, the pen holder of this year resolution of the rights of the child, Uruguay will intend to present several of the points reasoned in this event, both in our first draft, but also when trying to achieve a consensual document throughout the negotiation. Among other things, we prioritize the need for a justice system that guarantees equal access, protection, and support for children, tackling, as it has been said, the invisibilization of children in the legal system. As this is a particularly important aspect that has been mentioned by several panelists today from different parts of the world. Uruguay also intends to highlight the need for free legal aid when needed, and also to avoid the detention of children due to their parents' alleged association with armed forces, including those designated as terrorist groups, as children are not to blame for this situation. We also take note of the fact that children should not be considered powerless actors. That has been written as well. Therefore, we'll try to include references to human rights defenders to exercise their civil and political rights in the text that we will share with member states. An important part of today's work should be to acknowledge that children are actual actors in our society and have to be respected and considered when legislating and implementing policies. All these aspects will be put in the table by Uruguay in our first draft, but will also be considered and defended when negotiating the text with our partners of GRULAC and the European Union. Finally, Uruguay would like to thank again the organizers, many of whom are important partners to our country in this defense on the rights of the child. Having carefully listened to all of you, civil society, different NGOs, member states, but also the several UN agencies that did not take the floor today, but make a super important work. We acknowledge the extremely delicate situation of children, especially girls, and also especially in this context of COVID-19. This awareness should stick to us, many of us UN delegates, when negotiating and defending positions in this forum. Thank you very much.
Thank you, sir. And we are very fortunate to have Uruguay as a champion of this issue in intergovernmental negotiations. I'd like to turn the floor now to Ms. Juliet Harris, Director of the Scottish Alliance for Child Rights.
Thank you. It's a delight to be here and really inspirational to hear the previous speakers. I wanted to highlight that through the tireless campaigning of children and young people, we've made great strides in increasing understanding of the importance of access to justice in Scotland. As a result, the Scottish Parliament has recently passed a law that will incorporate the UN Convention on the Rights of the Child into Scots law. When it commences, this new law will make children's rights binding rather than guiding on all levels of government. And this new law contains many important provisions to improve access to justice for children and young people. For example, all levels of government and those commissioned by government to provide public services such as health and education will have to act compatibly with the UNCRC. And if they breach UNCRC rights, children, their representatives, or our Children's Commissioner can actually challenge this breach in the courts. There are also no time limits on proceedings until children reach the age of 18 years old. If, for example, a child's rights are breached when they're 7 years old, they can still bring proceedings up to the age of 19. And furthermore, Scottish ministers must report every year on what's being done and what they plan to do to raise awareness and understanding of children's rights and ensure that children can participate in decisions that affect them, including through access to complaints and advocacy services. This new law has been challenged by the UK government in the courts for going beyond the powers of the Scottish Parliament, and we're nervously awaiting a judgment from the UK Supreme Court that will set out whether or not this law can commence as it stands or whether it actually needs to be revised. But until then, we hope that our work in Scotland through this bill and through the incorporation of the UNCRC into law will provide inspiration to others across the world who are striving to improve access to justice for children.
Thank you, Ms. Harris. It is indeed a very inspiring example. Our next speaker is our friend and colleague from Child Rights Connect, Mr. Alex Monter, and allow me to thank you for the excellent and important role you've played in organizing today's event as I give you the floor.
Thanks very much, Genevieve. Yes, as one of the co-organizers of this event, the Child Rights Connect network welcomes the initiative of the committee to lead on this issue of children's equitable access to justice, noting that this is the first time this important topic has been addressed within the framework of the HLPF. The HLPF has helped draw international attention and commitment to access to justice. Regrettably, however, we continue to see, as we've heard today, major gaps when it comes to children's access to justice, further exacerbated by the COVID-19 pandemic, during which time attention to children's rights has dramatically decreased. So a better understanding and more serious commitments and child-specific action are needed by all stakeholders, including states, the UN, civil society organizations, to ensure that child victims of human rights violations have access to effective remedies and reparation. And we hope that today's event marks the beginning of a concerted effort by all to those ends. As part of a holistic approach to ensuring national to international redress for children, we call on states to ratify the Opec. This is integral and indispensable to enhancing child access to justice through an international child-sensitive mechanism that can fill gaps at the national level and further advance the full implementation of the UN Convention on the Rights of the Child. As was illustrated by the video shown earlier, the committee has already assisted states to realize child rights through the Opec. Further to this, we would encourage everyone to look at our recent Opec ratification toolkit, which can help all to understand how Opec is essential to enhance access to justice for all children and what to do to advance ratifications. We at Child Rights Connect stand ready to work with all stakeholders to those ends, including on a technical basis with states. I thank you.
Thank you very much, Alex. And with the indulgence of all our panelists and friends, participants here, we will extend a little bit beyond 9 because we still have a few speakers who'd like to take the floor. Our next speaker is a former member of the CRC, Mr. Nevin Vukovic Sahovic, who's also the founder of Child Rights Center in Belgrade. Nevin, you have the floor.
Can you hear me?
Oh, sorry, I said Mr. I apologize.
It doesn't matter. At my age, it doesn't matter. Yeah, thank you very much for organizing this meeting and for giving me opportunity to take the floor. And I can share with you that I was the proud member of the CRC committee when the Opec was being drafted, and we tried to contribute as much as possible and work with the states to have the document that it's so useful these days. And also congratulations to children and all the human rights fighters and defenders that we listened to today. And actually, I just wanted to share with you something that in the recent years, maybe last 5-6 years, I've been working a lot supporting governments around the world to understand the state reporting and to draft state reports. And in that, of course, I relied a lot on the guidelines for the reporting. And the funny thing is that I insisted that the states include in their reports information about access to justice. But then the states would tell me, the drafting groups would tell me, but it's not in the guidelines. So my questions for Mikiko, but also for Benoit and Anne, who are here, is can we expect to have this guidelines revised? I think that would be very, very important, and because we have lots of material in the general comments and in whatever we do, and we have to take into account that we know for sure that 80% of adults, the OECD has this information, doesn't have access to justice. So this number must be much, much higher for children. And maybe the states, what I see, they just don't understand what this is all about. So if we can have it included in the guidelines, maybe we can have a better response. I thank you very much again for this meeting and for giving me the opportunity to take the floor. Thank you.
Thank you, Ms. Vukovic. I now give the floor to Ms. Rosario Ojinaga. Ms. Ojinaga, you had raised your hand. I don't know whether the organizers need to give her the floor as a non-panelist. I see that you are muted. Okay, we will come back to you. Let me now give the floor to Xoli, who is part of an organization accompanying here our child rights activists from South Africa.
Hi everyone. I won't be able to turn on my video because the lighting in this room is very bad. So I'll be speaking through without lighting the camera. My name is Yelam Gogwana. I'm from South Africa. I'm 13 years old. I'm a climate justice activist. In our constitution, it says children have a right to a full life, being able to be happy and healthy. I live in Khayelitsha, which is a big township in Cape Town. I already fetched the water from our house from a communal tap. When we go to the bathroom, we use pit toilets. These are dangerous. They're not safe and they're not clean. And some township parents have to surround their children to make sure they don't get shot by gangsters on the way to school. So I am already living in this future that others fear. There are large numbers of people in Khayelitsha who don't have enough to eat. We don't have enough water supply. With all of that now, I have worry and stress about taking the government to court for not protecting the future I was promised. So my question is it hard to ask if adults can do their job so we can be children and be happy and healthy? Safety is the biggest concern in South Africa, as we have seen killings of activists. I am wondering how other young people navigate this. Also, as we all know, litigation and children's rights are not homogeneous issue and need to be assessed and looked at from the lens of each country, so no child is left behind. Thank you.
Thank you very much for your powerful words, Yoanka. Let me check if Rosario is able to take the floor now. Rosario Ojinaga. Unfortunately, we cannot hear you. So what I would suggest now is I would like to first turn to our chairperson of the CRC, Ms. Otani, for her reactions to the comments made and the discussion thus far. And if you can combine this with your parting remarks as well, Ms. Otani. And then we will see if other panelists who are still able to be with us also want to complement.
Thank you very much for giving the floor. Firstly, I'd like to thank all the panelists, and in particular, the young children from South Korea. I was so inspired by hearing their presentations, because despite all the obstacles, you told us that you were empowered by using the law and filing a case in the court. It's a very, very inspiring story for us and encouragement for us. So thank you very much. And thank you for all the questions which are put in the Q&A. And I was just typing the answer to our former member of the CRC, Navida. Thank you for your questions or suggestions. Actually, I think this is a wonderful way to put the access to justice in the reporting guidelines, so that we can ask all the state parties, 196 countries, to report us the access to justice. And it's by doing that, we can highlight importance of the access to justice in the reporting procedure. So I definitely take this up to the discussion in the committee. So thank you very much for all your very valuable comments and questions and interventions. Thank you very much.
Thank you, Madam Chairperson, and thank you for making this issue a priority for the committee. Can I check if Dohyeon or Yujin would like to also react to what has been said today and give us some final comments?
Yeah, sure. I can start. So it was really meaningful listening to all the panelists. Again, thank you for your powerful words and also for all the work that you've been doing. And personally, it was also meaningful to hear from my fellow activists from South Africa. I thank you also for the work that you've been doing. And I'd like to end on a message of solidarity to my fellow young activists, because even though we may be speaking about different issues, we are essentially demanding a safe future for us young people. So yeah, thank you.
Thank you so much. Dohyeon.
Today's event was really great, and personally, this event was an opportunity for me to think about what can be done better in my country to improve, the access to justice in South Korea. For example, I was really impressed by the presentation given by Theoni from Greece, because we do not have a exclusive child ombudsman system in Korea. What is happening in Greece was really insightful, and has enabled me to get those meaningful insights about other countries' situations. So thank you very much. And yeah, it was nice just to be able to, speak in front of all these people who have excellent expertise in child rights. Thank you.
Thank you. And as I think you and Yujin heard, you were an inspiration to us all. Ms. Peñaherrera, any closing remarks or responses from your side?
Bueno, pues de mi parte, un agradecimiento profundo a quienes han intervenido, a mis compañeras de panel. Realmente sus experiencias son conmovedoras e inspiradoras. Y decirles que sí, que nos toca trabajar en condiciones poco favorables, con muy poco apoyo estatal, pero que también es conmovedor el compromiso que se va generando también desde las comunidades cuando pueden ver que los derechos de las niñas, de los niños, de las adolescentes se pueden conseguir, pueden ser reales. Es realmente bonito ver cómo madres de familia que miran que no pueden continuar con esa forma de vida cambian y pueden posicionarse a favor de los derechos de sus hijos y de sus hijas y ser verdaderas defensoras y defensores dentro de sus propias familias para poder romper estos círculos de la violencia. Ese es nuestro trabajo que nos toca y bueno, pues decirles que me ha gustado mucho participar aquí y agradecerles mucho por crear este espacio para conocer experiencias distintas de defensa de los derechos de las niñas, los niños y las adolescentes. Gracias.
Muchas gracias a usted también. Aneta Genova, would you also want to answer some questions or make some closing remarks?
Thank you very much. I was extremely happy to be part of this event, and I want to thank you to all panelists and all people who intervene, but especially I want to thank you to the boy from Africa, his name was Gabriel, I think, who mentioned the need to prioritize the mental health of the young people. I think it's extremely important, and it should be some way to start working for prevention of the problems instead to follow the problem and act only when we are facing with something already happened. I think one of the main way to prevent mental health problem is to fight for the society free from violence. So because in my work I saw the link between violence and further mental health issues very often. So thank you very much for all these people who are working for prevention violence against children and creating a society free from violence. Also, I want especially to thank to the young activists from Korea who were extremely powerful and made me dream for more young activists in my country as well. So thank you.
Thank you so much. And Ms. Koufonikolakou?
Yeah, I also wanted to share that the activists were really inspiring, and that is amazing that they get power from getting familiar with the legal framework and how they can use it as a tool to raise awareness and to seek justice. This is truly amazing. I just wanted to say that the mere fact that services are not properly accessible by children is a reflection of our inability to build coherent and robust child protection systems in our countries. And that system should not only be reachable, but should also protect children from guilt and from secondary victimization, and equipped to protect minors in that way. And the last thing is that we should learn how to listen, carefully listen to what children have to say. It is so important, so essential.
Thank you. And a very important note on which to end. Let me close this very meaningful discussion by concluding that we have much work ahead. But with such powerful alliances and networks, we can make marked progress in the context of the SDGs. I would like to thank our 6 amazing all-female panelists, as well as the members of the CRC who participated today and co-sponsored this event, Child Rights Connect for co-organizing with UNICEF, our colleagues at the Human Rights Office of the United Nations, and the missions of Germany, Slovenia, and Belgium for being co-sponsors. Thank you, Madam Chairperson, for your leadership on this issue, and wishing all of you a wonderful rest of the day.